Welcome to FCPA Flash, the official podcast of FCPA Professor, moderated by Professor Mike Kaler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA.
Kreller has been the leader in enhanced due diligence involving FCPA compliance programs since 1988. Our boots-on-the-ground research combined with our in-house team of licensed investigators allows us to continually outperform even the most sophisticated database providers. For the past 30 years, Kreller has become synonymous with high-quality, decisionable reports that uncover hidden truths that our competitors routinely miss. Kreller also has a best-in-class case management system, Kreller Online, which allows for companies to develop and administer their own questionnaires, risk ranking scoring, and third-party training, while continuously monitoring the companies and shareholders through worldwide sanction lists.
Thank you for listening to the FCPA Flash podcast. This is Professor Mike Kaler, and I invite you to my next FCPA Institute in Nashville on May 3rd through the 4th. To learn more about the two-day FCPA Institute and how it has elevated the FCPA knowledge and practical skills of a diverse group of professionals, please visit fcpaprofessor.com and click on the FCPA Institute page. Welcome to FCPA Flash, sponsored by Kreller. This is Professor Mike Kaler. There are many people, of course, who have FCPA insights and perspectives, and broadly speaking, these insights and perspectives can be from private practice, representing clients in FCPA matters, from being a government FCPA enforcement attorney, and from being an in-house counsel with a company subject to the FCPA. Numerous individuals have at least two of these perspectives, typically a former FCPA attorney at the DOJ or SEC, now in private practice. But to my knowledge, just a small handful of people have what I'll call the trifecta of FCPA insights and perspectives. And in this episode, I'm pleased to be joined by one such individual, Adriaen Morse. Thanks for joining me today.
Thank you for having me.
Adriaen has over 20 years of experience as a lawyer in the SEC's Enforcement Division, in private law firms, and in-house with two global Fortune 500 companies, most recently as Chief Litigation Counsel and Chief Ethics and Compliance Officer. He currently practices law in the Washington, D.C. area with his own firm, Morse Law Office, PLLC. So again, Adriaen, what interests me in speaking to you and what I think our listeners will find very interesting and informative is your various vantage points when it comes to the Foreign Corrupt Practices Act. So let's perhaps go back to your time as an SEC FCPA enforcement attorney, and what specific vantage point of that position do perhaps in-house FCPA counsel and outside FCPA counsel fail to understand or appreciate?
Sure. Well, the FCC staff, first of all, tends to be relatively smart lawyers who've done well in law school. Many have been in large law firms prior to coming to the SEC, or they've been in prosecutors' offices. So they're not inexperienced. But few, if any, have ever been in-house, or even in some cases with lawyers of the prior career, very few have been an executive at a company of any size. So what that tends to cause is SEC staff tend not to know how hard it may be to comply with some of the requests they make of a company. And this leads to sometimes what seem to be some pretty at least from the perspective of in-house counsel or outside counsel representing a company, some outlandish, I guess, expectations about how quickly something can be made to happen in an investigation. For example, on the data and email front, a company has to spend time locating data, downloading, processing it into a reviewable format, reviewing large volumes, and finally producing responsive material. and all the logistics that go into that are pretty much the province of an in-house counsel are pretty unknown to SEC staff. You know, they seem to have the perspective, and frankly, when I was at the SEC myself, I didn't appreciate how difficult this could be on the outside counsel and on the company that you're making these requests of. So that's sort of one big area is sort of just the frame of reference of an SEC counsel is not very informed by practical realities. It's more theoretical what they think a company should be doing. You know, and then on the flip side, the SEC staff, of course, has a much better handle on the objectives of the agency than anyone else involved in an investigation or an SEC proceeding. For example, you have organizational objectives filtered down through the SEC hierarchy that are disseminated to the enforcement attorneys, and that can affect the bargaining or negotiating or settlement postures that the SEC staff takes. So in some cases, these priorities and these objectives will dictate what they're going to be willing to discuss with outside counsel or the company in terms of negotiating an outcome. And, you know, so smart people, very good lawyers, a good grasp on obviously what the agency's objectives are, but, you know, not necessarily very sophisticated on what it takes to make things happen within a company.
So the first deficiency, I guess, for lack of a better word, that you mentioned is kind of a request for information and the burdens that may place on a company and not realizing the full extent of those, perhaps. Do you also believe that maybe SEC, FCPA enforcement attorneys lack what I'll just call some business chops? In other words, they're not very well experienced in the logistics of doing business in the global marketplace, in the challenges of doing business in the global marketplace. What are your thoughts on that?
Yeah, I think that's absolutely the case. As I said, it's a product a little bit, I mean, like I said, they're smart people, but their approaches to things are sort of what they learned in law school, what they may have absorbed for the most part for people coming from an outside a law firm practice into the SEC. A lot of people will have spent maybe 3 or 4 years at a firm, but you know, being at a law firm is not like being in a business, and they don't necessarily achieve there the type of perspective on nuts and bolts of running a business that you know you can acquire or at least appreciate when you're in-house later on in your career.
So what do you think the remedies should be for this? I mean, after all, both the DOJ and the SEC have called the FCPA a unique law. Both have specialized FCPA units. Shouldn't government enforcement attorneys in specialized units have specialized expertise in the law that they are overseeing and enforcing?
Certainly, and I think that the expertise on the law is pretty much there. They understand the law, they understand the regulations that they are enforcing, but what they don't understand necessarily is how that impacts the companies that they're regulating. And I think this is where the outside counsel and in-house counsel can be of value in the context of an investigation being conducted by the DOJ or the SEC. What I've seen sometimes is this attitude at times that I saw it when I was on the staff, and I've seen it since then. An approach to the SEC staff along the lines of how on earth can you even believe a fraud happened here, or only an idiot could think this is a violation of the FCPA. I'm overstating, obviously, but it's sort of that attitude toward the staff that's actually not very helpful when what you really have as outside counsel particularly is you may disagree that this is the fraud of the century, but generally the staff has a reason for why they think what they think. And from the outside, if you can identify what it is that's troubling them about your client's actions or the company you work for's actions, then you're far more likely to get a positive result because you can contextualize it for the staff and explain, here's what that piece of evidence that you're looking at really means in the context of the locale where they're working or the type of business that they're in. It's not very helpful to approach the staff who after all, are making a recommendation to the full commission ultimately, or in the DOJ's case, are acting for the Department of Justice. It's not very helpful to approach them with the view that, they're just buffoons. They're not. They're just not. They just don't have an understanding of the spectrum of issues that can arise in the real world, and they can be educated on it.
Yeah, just a brief comment regarding what you said a few moments ago. At least given some of recent enforcement theories, I think it's maybe even a debatable point whether the SEC and DOJ enforcement attorneys even have an understanding of the law. That's an issue. That's an issue perhaps for another day.
Right.
Let's switch gears to your specific vantage points from being an in-house FCPA counsel at large companies. What specific advantage point did you have from that position that perhaps government enforcement attorneys and even outside FCPA counsel failed to understand or appreciate?
Sure. Well, I think a lot of times the SEC or DOJ or outside counsel have the expectation that if the general counsel or someone in legal or compliance wants something done, then it's going to get done. And I think they assume this because in their minds, the legal and compliance functions in a company are pretty important, and that they believe that companies universally understand that and act accordingly. And, what I would say is in reality, that's not really how it works. Legal and compliance departments, whether they're, separate or together, depends on the structure of the company, but they're both cost centers. I like to say that compliance is actually a sales job. The chief compliance officer is an internal salesman, both to management and to employees. Some companies do try hard to give the CCO, I should say, a voice and a quote, seat at the table, like the government always talks about. But the bottom line is that there are misconceptions by SEC staff and outside counsel about the importance within the enterprise of the legal and compliance functions.
So what does that mean in terms of the grand scheme of things? Does the SEC or even outside counsel perhaps have unrealistic expectations about what can truly be accomplished in a multinational company with thousands of employees, or the speed in which that can happen?
Yeah, I think there's some truth to that. I mean, I think it's hard to make any large organization change course too quickly. I mean, everybody uses the aircraft carrier analogy. It's hard to get an aircraft carrier to turn. But, for example, outside counsel, for example, leading an FCPA investigation, that they often think that, if the GC, the general counsel, and the chief compliance officer are on board with an investigative approach or remedial action, then it's going to happen. And what actually happens is the outside counsel gives their recommendation, either just to the GC or to the company's executive team or in the context of an audit committee meeting. But, in that meeting, when the outside counsel is talking, everyone nods their heads. The outside counsel goes off, mission accomplished. But what happens after they're safely out of the room, the general counsel now has a sales job with corporate leadership to be provided the budget, the manpower, the other resources to actually make it happen. And inevitably, there are compromises all along the way as they go through the process of trying to implement something.
I mean, some people may take that comment and call, therefore, compliance or remediation pretextual or lacking in good faith, but I just think that goes to the difficulty of communicating and adhering to commands in a large multinational organization. Indeed, I've written before that, my gosh, if the SEC itself was subject to the internal control provisions, they'd have a lot of problems. That's not a unique criticism of the SEC, but let's face it, there are many, many companies that are just as large, if not larger, than federal government bureaucracies who have deficiencies in many of these same areas.
Yeah, I agree. I mean, like any other organization, I mean, companies are basically large groups of humans with competing agendas at every level. So nothing is quite as easy as, simply here's a written plan. You just have to implement it. What's the big deal? It's more complicated than that, and it's about modifying behaviors and habits and obtaining resources to do things. In the corporate environment, everybody is competing for resources. The people who actually control the levers of budgeting and providing and writing the checks, they're not lawyers, they're business people, and their priority is to achieve profits for the company. Now, obviously, they understand that when they're in the middle of an FCPA investigation, it's basically a corporate crisis, and funds have to be freed up. And usually, from the perspective of an FCPA lawyer, that's your point of maximum leverage to be able to free up those resources. But the hard part is the out years after the crisis has passed and the government has agreed with your remediation plans, and now the company has to actually implement them. What happens to that budget longer term? 2 years, 3 years after the fact? And it is subject to the same sort of pressures and erosion that every other budget in a company is subject to.
Now, your third vantage point is one you currently have, and that's as outside FCPA counsel. So what specific vantage point of this position do you believe that sometimes the government enforcement attorneys and even in-house counsel fail to understand or appreciate?
Yeah, well, I would say that SEC and DOJ lawyers tend to start from a position of skepticism about anything outside counsel says. From their perspective, the outside counsel is a hired gun in many instances. So for that audience, I guess this is more of a recommendation more than anything else, but when you're dealing with government regulators and prosecutors, it's important that outside counsel grounds statements that are made in observable, provable facts, because any statement that is made is going to be questioned. And the outside counsel's credibility, which some people come in with some built-in credibility from having been either with the DOJ previously or with the SEC previously, and so they are known to, maybe personally or by reputation, to the lawyers on the other side, and that can help. But by the same token, you can build that credibility within the context of the case by, on each occasion when you're meeting with the government lawyers, everything you're saying is provable and bears out over the long term and is never contradicted by anything. So the staff can be won over, and it's done by never over-promising or under-delivering on your arguments. On the other hand, I think in-house counsel sometimes expect, zealous advocacy in front of the government to look like an argument between their counsel and the government lawyers. And although there are times, I wouldn't say that never happens or it should never happen, and there are times when that makes sense. It's usually not at the outset of an investigation because, again, when you're speaking with the government lawyers, they are, for a large portion of the investigation, they're the ones who are making judgments and decisions about whether to recommend bringing an action against the company or the individual, depending on who you're representing. And it is important to persuade them, and you don't really have any alternative other than persuading them. You can't, there's no judge behind the scenes yet to go to complain and to make a ruling on a motion. So it's the staff you have to deal with. And so in-house counsel sometimes expect you to go in there, guns blazing. And what I always tell in-house, general counsel who may attend the meeting with me is, look, I explain this whole context, and I explain why, at least not until we get to the point of having made a submission and maybe we're talking to more senior people in the agency. We're going to try to persuade these people. We have to get along with them for at least the next several months or couple of years as we go through our process.
Or in the typical case, the next 4 or 5 years.
Well, yeah. I was being optimistic.
Yeah. So which of these 3 job categories, government enforcement attorney, in-house counsel, and FCPA lawyer in private practice, do you think is the most difficult, and why?
Well, obviously they all have their own unique difficulties. I personally think in-house counsel are in the most difficult position. They may be more aware of what's happening in a company and what needs to be done to address issues. But as I said earlier, they're viewed internally as a drain on scarce resources, and their programs to prevent violations, the compliance programs can sometimes appear to be mechanisms to simply say no to anything that carries risk. Now, obviously, every action carries risks, and well-designed compliance programs have to accept a degree of risk. But it's difficult to stand in the way of a significant piece of business, or on occasion to step in front of a determined senior executive who wants to do or say something that's improper. You have to remember the power in a corporation lies with the CEO and sometimes also the CFO. It doesn't lie with the general counsel and his staff for the most part. And so if in-house counsel thwarts something that would have been improper, the company moves on without having committed a violation, and that's good. But what happens to that counsel you may well find that person, that their performance evaluations may suffer, their bonuses become less lucrative. After a while, for no discernible reason, their services are no longer required. Nothing that you could put your finger on, but these things can happen. And even if they don't happen, it's a possibility that in-house counsel, consciously or subconsciously, do keep in mind.
The goal...
So I think that's a tough position.
Yeah, no doubt. And there are a few other individuals who similarly have this trifecta of experience like you have. And the answer of in-house counsel being the most difficult has, so far been the consensus answer there. The final,
not surprising.
Yeah, the final question is, let's face it, the goal of the FCPA, the objective of the FCPA is to reduce instances of foreign bribery. I think all people can agree upon that. So which job category of the 3 do you believe can best advance the FCPA's laudable objectives?
I think it's really important to have the credible threat of SEC and DOJ enforcement to cause companies to continue to pay attention to these issues. I mean, I'm not saying that companies are eager to commit crimes and to pay bribes, because they're not. But they are set up to maximize profits for shareholders. And part of that means providing concrete incentives to drive up sales and business, like bonuses for new business, consequences for failures to meet growth targets or other goals. And in that kind of an environment, someone somewhere in a company is going to feel pressure to pay something if necessary to hit a goal. And the FCPA's enforcement, like the enforcement of other criminal and securities laws, is what I think deters executives from yielding to the profit incentive, and I think it also gives in-house counsel, as well as outside counsel, the tools they need to free up those resources to field effective compliance functions.
Today's guest has been Adriaen Morse. He is one of only a small handful of individuals, at least that I'm aware of, that has a trifecta of FCPA insight and perspectives. Former FCPA enforcement attorney at the government, former in-house counsel at several large global companies, and also an FCPA lawyer in private practice, currently running his own firm, Morse Law Firm, in the Washington, D.C. area. Thanks for sharing your insight and perspective with FCPA Flash Podcast listeners.